The U.S. District Courts. The journey for federal cases, those involving the U.S. Constitution, federal laws, or disputes between states, begins at the lowest level, the U.S. District Courts. These are the main trial courts of the federal system. If you imagine a courtroom drama with a judge, a jury, witnesses testifying, and lawyers presenting evidence, you are picturing a district court. The country is divided into 94 federal judicial districts, including at least one in every state, plus the District of Columbia and certain U.S. territories. Bankruptcy courts operate as units of the district courts. It is at this level that the facts of a case are established and a verdict is reached. For the overwhelming majority of federal cases, the legal journey both begins and ends right here. The U.S. Circuit Courts of Appeals. This is the first level of appeal. If a party loses a case in a district court and believes a serious legal error was made, they can appeal to the appropriate circuit court. It is critical to understand that this is not a new trial. There are no juries, no new witnesses, and no new evidence. Instead, a panel of 3 judges reviews the written record from the trial court and listens to oral arguments from the lawyers to determine if the law was applied correctly. Most appeals are decided by 3-judge panels. In rare cases, a circuit may rehear a case en banc. The 94 federal districts are organized into 12 regional circuits, each with its own court of appeals. A 13th appeals court, the Court of Appeals for the Federal Circuit, has nationwide jurisdiction over specific types of cases like patent law and certain other specialized matters, such as international trade and claims against the federal government. The Supreme Court of the United States. This is the highest court in the federal system and the final arbiter of the law. The Supreme Court is not required to hear every case appealed to it. It chooses its cases very selectively. Of the thousands of cases appealed to it each year, the 9 justices will typically hear about 60 to 80 of the most important ones. To appeal, a party files a petition known as a writ of certiorari. The justices follow an informal rule of 4. If at least 4 of the 9 justices agree to hear a case, it is accepted. The court typically chooses cases that present a significant, unresolved question about the Constitution or to resolve a circuit split, where different circuit courts have issued conflicting rulings on the same legal issue. The court also has very limited original jurisdiction, such as certain disputes between states. The Supreme Court's decisions are final and establish a binding precedent for every other court in the nation. Thanks for watching. What other topic should I cover next? Let me know in the comments, and don't forget to like and subscribe for more explainers.